Most people assume that when someone is convicted of a federal crime, a jury looked at the evidence and decided that they were guilty. That's not how it works. In federal court, the overwhelming majority of cases end in guilty pleas, not jury verdicts. In fiscal year 2022, about 9 in 10 federal defendants pled guilty, according to data from the Administrative Office of the U.S. Courts analyzed by Pew Research Center. Trials are rare, acquittals are even rarer, and that should stop you cold. Why? Because when you dig into why that number is so high, you will find something that does not look like justice. You'll find a system that is structurally designed to extract pleas, even from people who did not do what they are accused of. My name is Michael Quiel. Years ago, the Department of Justice charged me with serious felony crimes. I launched a grueling battle against full force of the federal government. After a long and determined fight, I achieved victory against the DOJ, which is why I now lead this investigative organization. The organization I run has over 30 years' experience as an investigative news agency that has helped vindicate more than 1,200 people, defeat wrongful charges. I have witnessed the federal criminal system from both sides. As a journalist exposing injustice, and as a defendant caught in its machinery. What I'm going to show you today is not theory, it's the government machinery in action. Let's start with what that statistic actually means. Depending on which federal data set you look at, the plea rate comes out slightly different, but the story is the same. The federal judiciary's case termination data shows that 9 in 10 defendants plead guilty. And among people who are ultimately sentenced in federal court, the U.S. Sentencing Commission data shows the vast majority were convicted by guilty plea. Decades ago, trials were more common than they are today. Over time, plea bargaining became the default outcome in federal criminal cases. That shift did not happen because defendants started getting better deals. It happened because the tools prosecutors used to extract pleas became more powerful. Here's the part most people never hear. A significant portion of people who plead guilty are not guilty of what they pleaded to. Some are guilty of something lesser, some are not at all. Researchers at the National Registry of Exonerations have documented hundreds of cases where people pled guilty to crimes they did not commit. Innocent people who said that they did it, who signed paperwork admitting guilt because the alternative was worse. Why would an innocent person do that? Let me show you exactly how this happens. Mandatory minimums as a weapon. Federal sentencing system includes mandatory minimum sentences for a wide range of offenses: drug charges, gun charges, fraud charges. These minimums remove discretion from the judge. If you're convicted at trial, the minimum sentence is what you get, regardless of the circumstances. Prosecutors know these numbers, defendants quickly learn them, and the math becomes a trap. Here's a real pattern you will see in federal cases. A defendant is charged with a crime carrying a mandatory 10-year sentence. The prosecutor offers a plea to a lesser charge with an 18-month cap. The defendant knows they are innocent, but also know that the federal jury trials carry an 83% conviction rate, and if they lose, they're going to look at a decade away from their family, their job, and their life. So the innocent person does the math. Not a moral calculation, a math calculation, and sometimes the math says plead guilty. That is not justice, that is leverage. Tool 2, pretrial detention as punishment. Bail in the federal system is not designed to ensure that you show up in court. In practice, it functions as a preview to your sentence. Federal prosecutors can and do argue for high bail or no bail based upon the charges alone. If a judge agrees, you sit in a detention facility while your case proceeds. Federal cases are not fast. Federal cases can drag on for months, sometimes years, which increases the pressure to plead. So now an innocent defendant faces this calculation, fight the charges, stay locked up for 2 years while your case is built, and then go to trial where 83% of defendants lose, or take the plea today, accept the time, served credit, and go home to your family. Again, the system does not need to be corrupt to produce this outcome. It just needs to make the math work against you. Tool 3, financial exhaustion. Federal criminal defense is expensive. Attorneys with federal criminal trial experience bill at rates from $300, $1,800 an hour. A contested federal case from indictment through trial can cost anywhere from $50,000 to millions of dollars. Most defendants do not have that kind of money. The ones who do often spend it before trial. When the money runs out, the fight often ends, not because the evidence changed, but because the resources did. A defendant who has spent everything they have on their defense and still faces uncertain trial outcome is far far more likely to accept a plea than one who has full resources and confidence in their team. Prosecutors know this. Extended timelines, aggressive motion practice, and discovery requests that require enormous response resources all serve as the same function: drain the other side. Tool 4, the trial penalty. There is a term that defense attorneys and legal researchers use: the trial penalty. It describes the documented gap between the sentence a defendant receives after losing at trial versus the sentence they would have received under a plea agreement. The Sentencing Project and other research organizations have studied this gap extensively. In federal cases, defendants who exercise their constitutional right to trial and lose often receive substantially longer sentences than the plea agreement offered. In some analysis, the difference can be multiples depending on the charge and the sentencing rules. This is not coincidence. It's a feature. Trial penalty exists because the system needs to exist. If trials produce similar sentences to pleas, defendants would have much less incentive to waive the right to a jury. Courts would be overwhelmed. The system would slow to a halt, and the efficiency that current plea rates provide would collapse. So the gap is maintained deliberately, and every defendant who sits across from a prosecutor and hears a plea offer knows, even if nobody says it out loud, that the alternative to accepting the offer is substantially longer sentence if the trial goes wrong. That is not justice. That is a structural incentive designed to extract guilty pleas regardless of actual guilt. You may be watching this because you're facing charges right now, or you're trying to help someone who is, or you just a person who assumed the criminal justice system operated the way the civics class said it did. Regardless of why you're here, this matters because the plea rate is not just a statistic about other people. It's a description of how the system will behave if it is pointed at you or someone you love. The plea deal is presented as mercy, as a way out. Sometimes it is the right strategic choice, and an attorney is best positioned to evaluate that. But sometimes it's a trap dressed up as an offer. And the people who are at least able to resist it are the people who are the most exhausted, most afraid, and most isolated from anyone who can tell them the truth about what is happening to them. That is the gap the U.S. Observer was built to fill. Not to replace attorneys, not to give legal advice, but to be the voice that the system cannot legally silence, and to put documented truth into the record before a single plea is ever signed. The system runs on guilty pleas, remember that, because the system is counting on you not knowing what it means. If you are watching this and you or someone you know has just been charged with a crime, I want you to see the next video on this channel before you do anything else. I recorded it specifically for people who are in that situation right now. 5 concrete things to do before you take any other action. It will not tell you what a lawyer tells you. It will tell you what I know from 2 decades of watching cases get won and lost before they ever reach a courtroom. I'm Michael Quiel. I will see you in the next video.